Hello and welcome to Legalese. I'm Ernie Hyde, your host. This program is brought to you by the Northern Middlesex Bar Association on a monthly basis, and we're going to talk about estate planning considerations that you should think about before going in to see an attorney about an estate plan. And with me today I have Robert C. Markley from the law offices of Robert C. Markley, PC in Littleton, Mass. Welcome, Robert. So let's begin. We've had a number of shows of late, one on estate planning basics. So we've talked about things like wills and what they are, and trust and what they are, and the other sorts of documents, healthcare proxy, durable powers of attorney, and so on. But one of the questions I get on a regular basis when a new client in particular calls up and says, I'd like to come in and talk to you about a will, what should I bring with me, for instance? And so that's kind of what we're going to try to address today, so that when people do call in to set up an appointment with an attorney, they at least have done a little bit of their own homework and are more prepared to discuss their actual estate plan. So let's talk about one thing that they have to consider, and that is if they're doing a will, personal representatives, we call them now, the former association of that job, if you will, was executor, executrix, and administrator, and so on and so forth. But we call everybody a personal representative, so what type of person are we talking about?
Well, for the most part, you're generally going to want to have a family member. They are the ones that know you the best, know mostly what your wishes are, most likely to be on top of things when it comes time to administer the estate. It doesn't have to be a family member, although that's generally what I advise people. Now, normally it's your spouse and then one of your children, traditionally how it's done. Although
in succession?
Yes. Mm-hmm. Yes, so you have a personal representative, and then you have a separate section where you list alternatives in the event that one of the preferred personal representative is unwilling or unable to fulfill their duties.
Right, has predeceased the person or whatever. Right.
Correct.
Yep.
Or has become incapacitated in some regard.
Fashion. Right.
They definitely need to be organized. There's a few parts of the estate where that comes in very handy. One is in the inventory, where you have to go through and create a list of all of the various major items, not knickknacks or things like that that can fall under the general miscellaneous personal property listing.
Right.
But automobiles, you'll need the make, the model, the VIN number, what the Blue Book value is, and this is all at the time, the value at the time the person passes away.
Right.
A list of stocks, bonds, along with certificate numbers, bank accounts, any life insurance where there isn't a designated beneficiary, right, or the designated beneficiary has predeceased the person drafting the will. Then there's a second part, which is the accounting, and that's even more detailed. What that does is that takes into account all of the expenses of the estate, the funeral luncheon, headstone, attorney's fees, filing fees. So you need to keep a detailed check register of all of the various expenses that you pay out from the estate. You'll need to file that to close the estate at the end. So if you have somebody who's very organized, it makes it a much simpler process, and for most people there will be less attorney's fees because the attorney has to do less work sorting out what's an expense, anything that's come into the estate, things like that.
One of the other things that you would have to account for on the inventory is any real estate primary residence and other.
Right.
If there
any
were other.
second homes, investment properties, whether in this Commonwealth or in another state or Commonwealth.
Right. Okay, and then you're right, the accounting at the end. Now, under the new probate court rules that came into effect March of 2012, seems like forever now, doesn't it? An accounting doesn't necessarily have to be filed with the probate court, but you should always prepare one in case someone challenges it, and then it's ready to be filed if you need to do that.
Yes, and correct. And there are several different types of estates. You have an informal, you have formal.
Right.
So that's a little off the topic of what we're discussing today.
That's usually an attorney's call anyway. And
Right. If there's real property, real estate involved, then you need to do a formal. That's pretty much it. The informal is a little less costly, not quite as detailed. And then you can go from an informal to a formal if somebody, one of the heirs say, objects, or if one of the devisees in the will thinks that things aren't being handled properly, they can open an adverse hearing in the formal. Once that is resolved, then you go back to the informal.
Informal, right. Okay, and you mentioned that you recommend that family members be personal representatives. Have you ever run into a situation where, after discussing with your client what the family makeup is, that you say, oh, maybe we ought to get someone outside of the family to do this?
I personally have not run into that, although I do know that does occur. And the personal representative does not have to be a family member. It can be anybody over the age of 18 who has legal capacity. So literally anybody. I know that on occasion, sometimes attorneys will handle the personal representative duties. But for the most part, it's usually a family member. You could have a friend do it. Say you're not married, you don't have any children, your parents are predeceased, you don't have any siblings. Although I would usually try to recommend finding a maybe an aunt or an uncle or a cousin. If they are in Massachusetts, it makes it a little easier, although they can be out of state. I have had a number of clients probating estates in Massachusetts that are not here. Right. And you don't, as a personal representative, don't actually have to physically set foot in Massachusetts to handle the estate unless there is, an adversary proceeding or something of that nature. Everything can be done by paperwork from where you live. Right.
And that happens, and it does. Okay, so if you know the family and you know the, let's say, children, if that's where we're at, the spouse, then the children, and you know that they don't get along, and you know that there's constantly infighting in the family, still recommend family?
In a situation like that, there's two things you can do. You could stay within the family and see if you can get a consensus, or
among the children themselves.
Correct.
Right. Okay.
Or it's I don't know. I mean, it really depends on how bad the infighting is, I suppose. Yeah. If it is completely beyond repair, if there's no way that you think that anybody can reach any kind of agreement, then I would recommend finding somebody outside of the family. Although if you do draft the will properly and handle the estate planning properly, then even if there is major disputes among the children, you have everything in place. Mm-hmm. The will describes how everything is going to be divided. Right. So even though they might be unhappy with it, there won't be very much that they would be able to do. They would basically have to accept it if you do everything properly.
Right, right. Okay, and I think it's important to understand that even though family members can get into those situations where they don't believe anything their siblings are telling them. There are court processes to object to what is going on in the state, and there is a trial process to go through, a litigation process, but it does become expensive.
Right,
And so for people out there preparing to have a will done and choose a personal representative, it's something they want to consider ahead of time.
Right, and there are a couple of stages at which somebody could object. There is the filing of the initial paperwork to name the personal representative. There's publication that goes along with that if you don't have the assent of everybody who is in line to receive something out of the estate. And I have had situations like that. When that happens, there's publication, and then there's notice sent to the various people, and they have 30 days to object.
Object to it, yeah.
They can also object to an accounting. They can request the court, they can petition the court, I should say, to demand an accounting of the personal representative. So there are a number of things that people can do that are unhappy with the process, but it does add time and expense to the estate.
Right, which you hopefully will try to
minimize
as an attorney when you do the estate to begin with. Okay, so I think it's important to emphasize the person who is going to act in your behalf when you're deceased should probably be diligent, organized, and at least an accepted representative of you to your family, because that's where any objections are typically going to come from, if there are any. Okay, what about attorneys in fact? Now, an attorney in fact is someone who is appointed with a durable power of attorney, stating that I give the power to act on my behalf in my financial affairs to this other person. How do you describe that person? What should they be?
Well, first of all, again, I recommend a family member because I think as far as the durable power of attorney, honesty has to be the number one consideration, because as soon as you sign that durable power of attorney, you're basically giving that person control over your affairs. And as such, you really want to make sure that they are going to act in your best interests. That's separate from the healthcare proxy, which deals with all medical decisions. The durable power of attorney is basically everything that's non-medical except for paying the medical bills.
Right.
Well, at least when I do durable powers of attorney, I try to be as broad as possible. So it's handling real estate transactions, mortgages, notes, banking, stocks, bonds. You're basically going to control every asset that person has.
So you want that person to be, again, organized, obviously, but you want them to have some sense of finance or the ability to manage financial affairs. And you can typically judge that with, if they're family members, how they do their own.
Absolutely.
Because they are a fiduciary and have to act on your behalf in the best light that they can, which is the way they would act with their own assets.
Absolutely,
Right?
yes.
Okay. So let's talk a little bit about healthcare proxies. You brought it up, and that's an important issue. What type of person are we looking for there?
That is somebody who is, since they're going to be making the medical decisions for you, you certainly want somebody with a calm demeanor that will, objectively look at the situation. Somebody who's not going to act on emotion. It certainly is a very emotional job to have a healthcare proxy or be the healthcare proxy for somebody, and it's usually, again, a family member. So that's can be even more emotional. Although there are certain things that can be put into the healthcare proxy to make it easier for that person. These are called advanced directives. So they can range from do not resuscitate orders, not to be kept alive by mechanical means, no feeding tubes. So if you already know certain ways that you would like to or not like to be kept alive, you can put those into your healthcare proxy, and then that takes away the responsibility of making that decision from your healthcare proxy. So it'll make it a little bit easier on that person when it comes to making medical decisions.
Yeah, to an extent that's accurate in giving the power to the proxy to make decisions for you, but at the same time giving them, as you say, advance directive to do that. But is it possible they could ignore that directive and say, that was written 10 years ago. I'm not going that way.
I actually haven't had that situation arise.
Well, you don't very often.
Yeah,
Yeah,
I know.
yeah.
But, excuse me, that's something that should be honored, because they're the wishes that you've made while you're legally have legal capacity
Right.
to make these decisions.
Right.
Now it's a little bit different than what you would find in a
Living well.
right. I was going to say that if you've gone to a hospital before, you might know somebody who's had this experience. They actually have forms that you can
Right,
fill out,
right,
but they're
right.
usually only a page long,
Mm-hmm.
maybe 2 pages,
Mm-hmm.
and they're usually inadequate for most of the really difficult decisions.
Yep. Just an explanation for, because this show is shown in various states as well as Massachusetts, a living will is enforceable in many states. It's not in Massachusetts.
Right.
Massachusetts has decided, and I think rightfully so, at least from my opinion, that the healthcare proxy is a better way to go. And the reason I think that Massachusetts originally did this was knowing the potential advancements in medical care, in treatment and medications and so on and so forth. A healthcare proxy written 10 years ago will allow the person to make a decision today, 10 years later, after consultation with a doctor and so on and so forth, as far as medication is concerned, or treatment is concerned, and make the decision in today's environment, as opposed to following what would be in a living will, cast in concrete, enforceable in some states, not in Massachusetts, by the way, but enforceable in some states, that says, this is exactly what I want to happen. But you didn't know what the advancements were going to be in those next 10 years before somebody actually read that. Okay, so I think Massachusetts has gone the right way. Don't always say that, but in this particular case, they do say that. But many times, attorneys write both. Would you say that's true?
Yes, that's I suppose in the event that you move to a state that does recognize a living will as a legally binding
Yep.
document, that certainly would come in handy. Although since the living wills aren't enforceable, I don't actually write living wills.
I don't either. I don't either, to be fair. But I think some attorneys do it trying to give the healthcare proxy the direction. In other words, this is what the client thought at the time that they wanted. Here's your direction. But we know it's not enforceable here. Make your own decision. And I think, as opposed to what you talked about, the advanced medical directives, it is less enforceable. Even though now the courts are finding that they will accept it as evidence of where people should be or how they should be making the decision. But I don't think so far they've ever told a healthcare proxy that you have to make it that way.
Yeah.
Okay.
The law is slow to change.
Yeah, yeah, and it will continue to do that. Okay, let's talk about tax issues. You want to start thinking about your estate. My recommendation is that you put together a net asset spreadsheet or list or however you want to do it, so that when you step in front of an attorney, they have an idea whether they have tax problems to deal with or not, how they want to handle them, whether they have a need for a trust, and so on and so forth. How do you look at those things as far as taxes are concerned?
Well, for the most part, are you talking specifically about the taxes that you expect that might be paid upon
The debt.
Upon the debt.
The estate tax.
Right,
The estate
okay.
taxes, yeah.
So there are a few things that can be done, and I know we've discussed this on the show before, talking about estates. One of the ways that you can decrease the value of your estate to go below the federal and Massachusetts thresholds is by having a second person on your accounts, things to keep certain assets out of probate. So for instance, in a trust that's set up, and we won't go into the revocable, irrevocable, and all of those, but
we've done that. Yep.
if you set up the trust properly, then the trust assets will be considered outside of the estate, and you won't have any tax implications, at least as far as the estate is concerned.
Right.
Having a second person, a spouse on the title to your home upon your death, it automatically passes to the other person, so there's no estate tax on the value of the property, the real property, which is usually the most significant part of the estate, but does not have to be.
Yep. Okay, and as far as estate taxes are concerned, currently, we're in 2014. Currently, the exemption amount for federal is $5.34 million per person. And one of the nice things that the federal government did, believe it, there is, when they put this new estate tax program into effect a couple of years ago, I think now, at least this past revision has allowed portability, which of that $5.34 million, meaning that if the first person in a couple, married couple, first person dies, and they've done no estate planning, which would have been the trust that you were talking about, they don't lose that $5.34 million exemption. It can now be ported to the surviving spouse. In other words, when the second to die dies, they have over $11 million or over $10 million worth of exemption, so that there, in many, many, many cases, there won't be any estate tax from a federal point of view. This is not true in Massachusetts for Massachusetts estate tax. The limit is $1 million, and you do lose it. If you don't take advantage of it through some sort of estate planning vehicle, you do lose it. So the second to die has $1 million that they can pass on tax-free. So that is an important subject, and I know every attorney looks at what do we have for assets, because if you don't look at that, then it's pretty difficult to even have an idea whether you want to do anything from a trust point of view. You agree?
Absolutely.
Yeah. Okay. Property ownership you just brought up a second ago, a very important issue in terms of who owns what. You want to go into more detail about why it's so important to not have everything joint, maybe, but in some cases, maybe it is important to have everything joint.
Yeah, that'll really depend on your particular situation. Usually you're going to want to have everything jointly held, although there are specific reasons why you might not want to. not necessarily from an estate planning perspective, but I know a lot of lawyers and doctors or people in professions that tend to be sued on a regular basis will not want to have property jointly held in the event that they do end up getting sued.
Right, right.
But as far as the joint ownership is concerned, one of the things you definitely need to think about is when you do that with a bank account, because as soon as you put a joint owner on that account, whether it is a child or something like that, they own everything in that account, so they can withdraw everything out of it if they want to. You're unable to stop them.
Yeah, depending on the ownership designation, whether it's in trust for or joint,
Right, that's kind
with
of a
right of survivorship.
general view.
Yeah, yeah, you always have to be aware of that. The other issue with ownership is occasionally, if someone does have an estate in excess of $1 million, and I'm speaking mainly of a couple, a married couple, that has in excess of $1 million, and they own everything jointly, then there's no way to plan for the estate exemption in Mass in particular, to take advantage of $1 million for the first to die, because the minute that person dies, everything is automatically owned by the second one by operation of law. So in order to make sure that there's something to pass to a trust, you'd have to have it in separate names at that point, right?
Right. If you're going to
some
create,
level of it.
Right. There are two different types of trusts. There's the inter vivos trust, which is what you create during your lifetime.
Right.
And then there's the testamentary trust, which is created by will. And yes, if you are talking about a testamentary trust, then there has to be something, the trust res, or funding for the trust.
Right.
So, right, if you create a testamentary trust, but you don't have any assets that can actually go into it, then the trust is going to fail.
Right.
Again, by operation of law.
Law, yeah, yep, okay. Couple other things that you ought to be aware of, and it's more of an attorney's issue to be aware of them, but you should be at least cognizant of the fact that they exist. Gift taxes, they still exist, even though I think it's $14,000 you can gift.
Went up from 10.
From 10,
Right.
yeah, it stepped up.
Yeah.
And so now it's about $14,000, it is $14,000 that you can pass on to any number of people, if you've got that much money, any number of people while you're still alive.
And that's per year.
Per year.
Right.
And avoid the gift tax.
Correct. Although that person receiving it might end up paying income tax on it.
Yeah, that's possible.
Right, right.
Yep.
So
Yep.
it depends. You might want to factor
that's
that
the
in
other side of
also.
it. Yeah.
But yeah, as far as the gift tax is concerned, there isn't any.
Okay. All right. Well, we've come to the end of our time again, and I'm getting the cut sign. So I want to thank you once again, Robert, for being
My
on the
pleasure.
show. This is several times for you now, and I appreciate it. And I want to thank all of you out there for watching, and hope you come back to see us again next time.